The laws in Nevada surrounding late fees and evictions are becoming increasingly more unfair to landlords, and I want to go over a couple examples of that today. So late fees in Nevada cannot be more than 5% of the periodic rent. So that means if your rent is $1,000 a month, the late fee cannot exceed $50. It doesn't matter if the person's 1 day late or 2 weeks late. That's the legal limit. Now, if we just go back a couple of years, you could charge whatever late fee you saw fit. I personally had a graduated late fee. It's late on this date for let's say $50. Every day there forward, it's an additional $10, $20, $30 or whatever the landlord decides. The point behind that is it motivates the tenant saying, I better get this paid. Whereas the law today really has no motivating factor. Once you've crossed the threshold of being late, why not be 3 weeks late? It doesn't really matter. The price doesn't change. Therefore, you have no motivation, no financial incentive to correct that mistake, which is what a late fee is there for. It's there to punitively affect someone in a financial way so that they correct the problem. That is what the design is. We're limited now legally to 5%. So $1,000 rent is a $50 late fee no matter when it gets paid. Evictions similarly have restrictions on them. We used to have a 5-day pay or quit. What that meant was once you were late, a notice could be posted on your door that said you have 5 judicial days to pay the amount owed or move out. And if you do neither of those, we can then take action in the court and file for eviction on you to ask the court to have you removed. 3 years ago, that process took about 3 weeks from start to finish. Now it's a 7 judicial day filing, so you have a 7-day pay or quit instead of 5. It added 2 judicial days. Not life and death, but judicial days aren't every day of the week. It's Monday, Tuesday, Wednesday, Thursday, no Friday, no Saturday, no Sunday, and no government federal holidays. So it really is a 2-week notice. In those 2 weeks, if the tenant chooses to not pay the rent in full or move out, then we can apply with the court as a management company or a landowner and say, I would like to have them evicted. Once we fill out that information with the court, the tenant in the interim has that time to fill out an answer. The answer says, I shouldn't be evicted. It could be literally, my shoe size is 11 instead of 12, so you can't evict me. It can be anything. They just have to scribble literally anything, I'm not exaggerating, on a piece of paper. It says, I shouldn't be evicted. And it will go to a court hearing. The problem is, by the time you finish mediation and a court hearing, it takes us about 4 to 5 months to get in front of a judge from the date we actually got the court case granted. So let's say it's March 1st. They don't pay the rent. I'm not allowed to consider rent late until 3 days after it's due. It's due on the 1st. On the 4th, I can say you're late. I can then file that paperwork on the 5th. Here you go, I'm going to give it to the constable. The constable is going to post it the next day, on the 6th, if it's not a Friday, Saturday, Sunday, or holiday. Then, the following day, the 7th, is when the count would start for the 14 days, which are really 7 judicial days. It comes up to about 14 days. So that's when the count starts. So we're at the 7th, now we're down to the 21st. So you'd paid rent late in March or didn't pay at all. Now you're at the 21st of March before I can file anything with the court. From there, it's going to be another 4 to 5 months. So now March, the end of March, end of April, May, end of June, July, it puts me into August before I can get in front of a judge. Now this whole time, the tenant's not paying rent. Who knows what's happening inside the place? They have every legal protection possible. The landlord has none. If during that time, that whole 5 months, the tenant pays even $1 toward the rent amount, the eviction gets thrown out. Because what the court says is we have taken a partial payment and we have accepted that as full payment. There's nothing we can do to get around that. A lot of tenants understand this. So if you're a landlord or property manager and you have an automatic system where a tenant can just automatically pay, they can go in and say, here's $10. And now that eviction process stops. If you take it all the way through to the end, it will get thrown out. So you have to start the process all over again by posting the notice, by waiting the judicial days, and so on. And it becomes a never-ending hobbling effect for landlords. So let's say you finally get to the end. You've got your court date in August from March not receiving money. The tenant in Nevada can then say, I have applied for CHAP, which means I'm applying for rental assistance. I haven't been approved yet. I'm just applying for it. The judge will say, okay, this case is now going to be stayed pending the outcome of their application. Maybe they get approved, maybe they get denied. If they get denied, they can apply again and again and still be given protections from eviction. The whole time, the landlord is still fitting the bill for these tenants the entire time, and there's nothing they can do. The tenant comes to the landlord, let's say, and he says, I want to pay $1,000 toward that. Well, the landlord now has to decide. If he takes the $1,000, all the other money that was owed in that time, the court will just dismiss it. So that money's gone. So landlords are put in a real bind, especially the ones that need that money to pay a mortgage. Like, well, if I take the money, at least I can float above water this month. But what happens to the money in the past? It's just gone. It's just gone. And there's nothing you can do. A further problem of this is as Nevada becomes more and more pro-tenant and more landlord averse, the rules are getting worse. So for example, the law says on NRS 118A.210, a late fee cannot exceed 5%, which we went over, of the periodic rent. What's happening to us a lot in court is judges will say, HUD, Section 8, paid 50% of their rent. The tenant owes the other 50% but hasn't chosen to pay it. You then cannot charge a late fee on the entire amount. You can only do it on the amount the tenant owes, which is not true. It is not right. The law literally says the amount of periodic rent, not the amount still owed, the amount of periodic rent. And Judge Brown in Las Vegas seems to have a personal vendetta against this law. His job is not to interpret the laws the way he sees fit. His job is literally to follow this law and apply it impartially to both sides. And that is not what is happening in the Las Vegas courtroom with Judge Brown. I don't know how to correct this. We've literally read the law, and he said, I don't think that's what they intended when they wrote the law. Does he know who wrote the law? Is he personally friends with them? And when did a law get changed based on a judge's interpretation of the intent on the people who wrote it? Shouldn't we just be reading the laws and abiding by them according to the actual meaning of the words in the laws? It seems a little crazy to me. But this is what a landlord gets to deal with every day when it comes to tenants and evictions and late fees. That's just one small portion of renting properties to people and what they have to go through to just be able to have some property rights and collect a fair rental amount in exchange for a reasonable place for someone to live. That's all they're trying to do.